next up, we have a session on family violence, visas and social security. And I'd now like to introduce Emmanuel, Senior Solicitor at the Immigration Advice and Rights Centre, Sally Cameron, CLE and Communications Officer at the Welfare Rights Centre, and our very own Emily Singh, Policy and Communications Officer at Economic Justice Australia and former Principal Solicitor at Social Security Rights Victoria. Thanks, guys.
Thank you, Leanne. Hope I'm not on mute. Perfect. So thank you for that wonderful introduction. Just bear with me as I sort my screen share. Sorry about this.
We can see it, Anne.
Okay, brilliant. Without the notes.
In presenter mode with the notes.
Lol. Let me fix that. How are we now?
Yep, still see the notes. Yeah, no, that's right.
Okay, thank you. Always some technical difficulties. All right, so myself, Sally and Emily are presenting today on the collision between immigration law and social security law. Before we get into the details of it, I would like to begin by acknowledging the traditional owners of the land on which we meet today, or I should say lands on which we meet today. I am joining from the lands of the Gadigal people of the Eora Nation. Emily is joining from Wurundjeri land, and Sally is joining from Gubbi Gubbi land. We would like to also extend our respects to any Aboriginal or Torres Strait Islander people present during this session today. We recognise that this always was and always will be Aboriginal land. And as well, in the legal sector, we would also like to note that any laws that we touch on today, we give that information as guidance only. If you do have a question about an individual, yourself or someone else, they should be referred for independent legal advice. So for this session today, Sally, Emily and myself are going to talk to you about that collision between migration and social security systems in Australia. This collision can leave victim survivors with no access or very restricted access to social security support. And for some, that means that the only real option is to choose between poverty and homelessness or remaining in an abusive relationship. We've broken down the session into a couple of points and there will be time for questions at the end. So I will give an overview of how being on a temporary visa might mean that there is no access to social security. Then Sally from Welfare Rights Centre will talk about access, with barriers. And she'll cover a couple of case studies for people where they have the newly arrived resident waiting period, New Zealand citizens, and also briefly discuss special benefit for children, Australian citizen children. Then Emily will talk about access that is tied to relationship status. We'll briefly touch on the need for reform and some of the advocacy that's already happening, and then we'll go to questions and discussion. There will be a place for questions at the end of each of our section as well. So I'd like to begin my little section by presenting a really common scenario. This is an example where there's been family violence. So I would like to say that working in the space can be difficult. If you do find this information triggering, you might hopefully want to take a break afterwards, maybe reach out for support as well. So as I said, this is quite a common scenario that we see. I'll read it out. So Ali is in Australia on a student visa. She has been in a long-term relationship with Mark, who is an Australian citizen. Ali and Mark have 2 children who are born in Australia and are Australian citizens. Mark has promised to apply for a partner visa for Ali, but over time he has used this promise to force Ali to do things that she did not want to do. Mark has also stopped her from contacting family and friends, from seeking work, and from attending her classes on campus. In the last few months, Mark has also started to become physically abusive. Ali is scared for her immediate safety and that of her children. She wants to leave Mark and take her children with her, but she has no income. She has reached out for homelessness services, but has been told that they cannot help her because she is only on a temporary visa. They have told her that she needs to get permanent residency before they can assist. So we have many clients who come to us in this or really similar situations. And visa status, as you can probably already see, can play into the experience of family and domestic violence in a number of ways. And I'll touch on a couple of these shortly. One is that it can be a factor in the actual nature of the family violence. It can affect access to social security, and it can also prevent other barriers for seeking safety. So visa status can play into how someone actually experiences family violence, or I guess some of the threats or actions that can be taken. So I did want to note that we describe this as immigration-related abuse, and you can see it in the scenario with Ali and Mark. This abuse can be using visa status to control, coerce, or manipulate an individual. Examples of this include things like threats to cancel or deport a person from Australia, cancel a visa or deport a person from Australia, to separate a parent from their children, threats to report a person to immigration, being the Department of Home Affairs, using the promise of sponsorship to control a person, or trying to coerce a person to return to their home country. If you want to find out more about that experience of how a visa can play into family and domestic violence, a good place to have a look at is this report by Monash University. I believe it's from 2021, so last year. In terms of how the visa status can affect, I guess, a person's options and access to social security, as you saw in Ali's example, she was told that she needs to essentially become a permanent resident before she can get access to certain support, and that includes social security. Unfortunately, from a migration perspective, there are not always solutions. One thing that we often have to tell clients and advise clients of is that there is no general visa for victim survivors of family and domestic violence. There is no general visa for compelling or compassionate circumstances. There are very specific, finite circumstances where family and domestic violence or compelling or compassionate circumstances is relevant to a visa application or a visa process. That means that many people on temporary visas do not have a pathway to a permanent visa, regardless of their experience or the risk of family and domestic violence. To put that into context from the visa perspective, there are several kinds of permanent visas. They fall into a number of categories, and I've broken them down on the screen. So there's partner visa. That's a visa that's based on being in a relationship with an Australian citizen or permanent resident, a de facto or spouse relationship. There are other family visas. They're in that category from the migration perspective. So these can include a parent visa, a carer visa, or a child visa. Again, sponsored by an Australian citizen or permanent resident who is the adult child, the person in need of care, or the parent of the applicant. Then there are humanitarian or protection visas. In broad terms, these are visas that are based on the risk of harm or persecution in a person's home country. They are not about the person's experiences in Australia. And to round it out, there are employer-sponsored and skilled or points-based visas. Of these visas, primarily only the partner visa has a consideration of whether or not there was family and domestic violence. So for people who are in Australia and they have already applied for a partner visa in Australia, they may be able to continue with their application for a permanent partner visa where their relationship ends, but there was family violence during the relationship perpetrated by the visa sponsor, the partner, or if there were children of the relationship. Unfortunately, in Ali's case, if there is no partner visa, so if Mark never made that partner visa application, she cannot apply for the partner visa post-separation on the basis of the family violence provision or the child of relationship provision. That leaves her in a very difficult situation. We, in advising her, would look at whether there's any other option, any other visa she could apply for in her own right. Often people in this situation where they're not working, they're unlikely to have an employer sponsor or enough points for the skilled work-related visas. That usually just leaves the question of whether they could apply for a protection visa. Is there a risk of harm on return to her home country? That means she could apply for a protection visa. It's a very difficult, complex visa, and it's not made for a situation where someone's experienced family and domestic violence. So what that means for giving advice to someone like Ali is that she does not have a clear pathway to a permanent visa, and then she's likely precluded from access to social security benefits in her own right. There are also other barriers that can affect Ali's experience and reaching out for safety and security. These include the fact, as we touched on, she's generally not eligible for Centrelink childcare benefits, public housing, even Medicare. She may have limited or no family support. In some cases, people have language barriers, so services might not have access to interpreters to be able to speak properly with the person they're trying to support. There may also be fear of social stigma, pressure from the community or family to keep the family violence private. She may have negative experiences or perceptions of the police or court. This can be from the experience in the home country, unfamiliarity with our processes, even insensitive comments made by people in authority like the police, such as minimizing or doubting a claim, assuming that a claim is made for the purpose of getting a visa, or misidentifying the perpetrator of the violence. And finally, we've seen that visa access can impact whether or not a person can get things like crisis accommodation, temporary accommodation, and access to even some charity and NGO support. So if you do have a client who is in a situation like Ali, I would recommend that you refer her to get some independent legal advice. This is one, so she understands what her partner can and cannot do, and what her options are, so she can make an informed choice to some degree about what she wants to do next, and also to make sure that she has explored her options and there are safety mechanisms in place in terms of who receives correspondence and things like that from the Department of Home Affairs. And our referral details are up on the screen. Are there any questions at this point?
Thank you, Anne. I think if you stop sharing your screen, we'll come back. There we go. We do have a question. The first question is, if the new government offered you the opportunity to create 2 more visa subclasses to address the gaps that you've been outlining, with these attracting special benefit and Medicare, what would they be and who would they cover?
It's a great question. So I will just touch a little bit on what we're going to talk about a bit further, which is the advocacy in the space. And the National Advocacy Group, which IARC is a part of, is advocating for initially a temporary visa to be there for people in this situation. part of that advocacy came around like what the previous government was likely to offer. So that's why we're revisiting what that, I guess, ideal of what a visa would look like. From my perspective, at least my initial thoughts are having a temporary visa that's like 3 years long, that's in place for anyone who is not a citizen basically and is not on a permanent visa, who's experiencing or at risk of family and domestic violence, that they could apply for. It wouldn't be an onerous process, nil or no visa application charge would be a great start. There's just such a risk when someone's in a situation like this case study we've put, that something will happen to their visa and they've got to be here even to figure out what they want to do next, like what happens with their kids, are there going to be family court proceedings? So having something that's pretty quick, hopefully with not a lot of evidence that would be required for anyone on temporary visa or even unlawful, I should say, that they could move on to have work rights, possibly access Medicare. That'd be a great start. And then from there, having a pathway to something that's permanent if they've got ties to Australia. I believe New Zealand has something like this in place. There are different models around the place, but just temporary is not enough for a lot of people. They might have kids here. They might still have reasons that don't amount to a protection claim for not wanting to return to their home country. And that can be enough to keep someone in an unsafe relationship.
Economic Justice Australia has had some involvement in that national advocacy group, and I remember we did advise that getting a new visa subclass would be easier than trying to adjust the requirements for existing payments to have special circumstances or domestic violence recognised. So I was wondering what kind of reception you've had to that idea of creating a new visa type?
So the previous government clearly wasn't receptive at all. The new government is still a bit uncertain. With the national advocacy group's work, they're currently in the process of revising the previous blueprint. So it hasn't been revised yet. It hasn't gone to the new minister yet. So it's a bit unknown. There have been some things that look positive, at least from a pretty skeptical lawyer, they look positive in that the Department of Home Affairs does have a family and domestic violence support team that they've created, and they seem to be quite receptive, at least from a policy perspective. Of course, they can't change the regulations. And even recently there were changes to one of the instruments, which meant that people who were on the partner visa pathway can now access the family violence provisions where they were precluded. There was a gap with the COVID concessions where a certain cohort who are here would not be able to continue with their partner visa application. So there have been little changes that mean that make me think maybe this new government will be more receptive than the previous, but there's still still time for them to prove me wrong.
One more question. In Ali's case, would there be any pathway relating to her student visa? The fact that she had not attended classes, would she be at higher risk of deportation?
So I'll probably answer the second part first. The fact that she hasn't attended classes would be a risk in terms of, like, she's probably not complying with her student visa conditions, and not complying with your visa conditions can be a reason for the department to consider visa cancellation. It is the department's policy that when they consider cancellation for things like not complying with your visa conditions, so not attending classes in this case, they can consider circumstances that were beyond your control. And the policy does say they will consider family and domestic violence specifically. as a circumstance beyond someone's control, it's still a risk. It's just what they say is just what's in policy. It doesn't mean they can't still cancel a visa. In terms of pathways, that would vary. I am by no means an expert on skilled or employer-sponsored visas or work visas, but I think the fact that she hasn't been attending classes, maybe she might not graduate, would mean that the most likely next step for a student visa is you're looking at a temporary graduate visa, and that requires successful completion of your course. So it's not great. There's not clear pathways.
Thank you. That's all we have in the Q&A. So over to Sally.
Can you see my screen? Great. So thank you for that, Anne, and outlining how the lack of pathways is just such a problem for some women who are here and experiencing violence. I'm now going to go through a couple of ways that the social security system responds in a, it's not quite ad hoc, but in a unsubstantial way to women who are on visas who experience violence here. The first thing we wanted to look at was looking back at Ali's situation and developing the case study, so that one night Mark assaults her so badly that he breaks her nose, cracks 2 ribs, and she's hospitalized for 3 days. After that, he begs her to tell medical staff that she's tripped, fell off the back deck, hit a railing on the way down. He says that now he can see he has a problem. It won't happen again, that he will put in the forms for a partner visa, which he does. So after that, things go fine for a while, but gradually his controlling and threatening behaviour increases. On the day they get the letter telling them that Ali has been granted a temporary partner visa, he loses it, physically assaults her, smashing things and punches holes in the wall, and she realises that she has to leave. So really, this scenario is about what are her options once she has a different kind of visa. So as many of you will know, the social security system runs according to a very strict set of rules about which visas are in and which visas are out. You can see that that's a snapshot of a table from the Social Security Guide. The third column, you'll see that they're looking at whether visas are temporary, but it really is that final column that is crucial. So you can't always tell just by looking at whether a visa is considered permanent or temporary, whether a person can access Social Security. So it's a matter of looking up the guide to check which visas are in and which visas are out. She happens to have a visa 820, which is the temporary partner visa, which, although it is considered temporary, it is treated similarly to a permanent visa in some ways. And she can access a limited number of payments. You can see there the codes are for special benefit, family tax benefit. There's a few other some superseded codes there, but that is basically a very limited number of payments. But this is where the newly arrived residents waiting period kicks in, which is a major barrier for many, many people. So the newly arrived residents waiting period, the NARP, is a waiting period that says that even though someone may be eligible for Centrelink payments, they cannot access them for a set period of time. It affects most Social Security and family assistance payments, and it starts the date that a person arrived in Australia or the date they were granted permanent residency, whichever is later, with the NARP, the length of the NARP differing depending on what kind of payment. Importantly, people who've become Australian citizens, refugees, family members of refugees, that's an important one, and people on temporary humanitarian visas are exempt. And also there are still just a few people who are still covered by the pre-January 2019 legislation. So there's a small group of people that, of course, ends in January next year, because the longest NARP that we currently have is 4 years. So most payments are under a 4-year waiting period, which means that people have to wait for years. And you can see there are a few that have a shorter waiting period, and just the two there, family tax benefit B and childcare subsidy, don't have a waiting period at all. And yeah, it's a long time. It's a long time. We found during COVID it didn't work at all, because when the shops were closed and people lost their jobs, suddenly the government realised the system doesn't work. Apparently it doesn't work when it's a lot of people, but not such a big deal when it's for a smaller number of people, and they temporarily waived their NARP. Now, importantly, in relation to domestic violence, there is an exception where the person is in financial hardship and where there's been a significant change in circumstances, and including with that is family and domestic violence. So for this case study, Ali may be able to apply for special benefit using this exemption that since arriving in Australia, there has been a significant change in her circumstances. The domestic violence began since she arrived here. And so she should be able to claim special benefit. So as I just said, it is vital that the change in circumstances happened after arriving in Australia. So if she'd been in a relationship with someone overseas and there'd been long-term violence before they got here, that wouldn't apply, but it started after she got here. And that top sentence there is basically from the Social Security Act. The next paragraph is really from the guide, which we know carries a lot of weight. What it says is that the change must have occurred after the person got permanent residency and came to Australia, or if they were already here, after they got an onshore visa that fits those categories that I showed you earlier. Importantly, though, when it comes to domestic violence, family and domestic violence, there is more flexibility included in the guide. It says it considers that family and domestic violence can be in exceptional circumstances, and it can actually apply if the violence started before the permanent residency began. So that is very important in the case of our client. I'd also say it's in the guide, it's important, but you know, the Act is not as strict, so always worth considering whether it's worth appealing if someone is unsuccessful. So what that gets her access to is special benefit, which is a discretionary payment of last resort, payable when people can't access other income support payments. They're in financial hardship, they can't work and earn a livelihood for themselves and their dependent, and they have to be present in Australia throughout the period. It's about short-term and long-term funds. Generally, if someone has access to $5,000, they can't get it at Welfare Rights. We've had a curious case when someone got a back pay of their special benefit. Their special benefit stopped because it was more than $5,000. And you know, they can do things like take into account whether someone has taken pity on a person with absolutely no income and let them stay in their house. That might be considered board and lodging, and that may reduce the payment as well. So basically, if Ali is able to make her way through the system, she should be able to access special benefit with the newly arrived residents waiting period, and also family tax benefit for her child, which is born in Australia, so there's no NARP. That's good. It's not great. It's less money than if she were on parenting payment, probably about $200 a fortnight less income. And as I said, if she manages to get a part-time job, it's going to be a way worse payment to be on than parenting payment. And just a note, and as Anne said before, we're very aware of the intersection between Social Security and immigration. The separation means she should still be able, hopefully, to pursue a permanent partner visa on the basis of her child and also the family provision, violence provisions. The other thing I just wanted to mention in this section is about the peculiar position of New Zealanders. So this is a different case study about Kerry, who came to Australia from New Zealand in 2013, and over the next 7 years worked her way up into management in a bank. In 2020, she married Dave, and soon after she got pregnant. After having the baby, everything changed. Dave insisted she couldn't go back to work, started blocking access to bank accounts, giving her $200 a week to pay for food, utilities, everything. Refused to pay for medical treatment for her or their daughter, saying he didn't see why he had to pay for everything. When she told him their daughter had grown and needed clothes, he told her to go to an op shop. When she asked for $50 to have a second birthday party for the daughter, he pushed her down the back stairs. She told him she was leaving him. He put a stop on their daughter's passport. So I've just got a little timeline here about the treatment of New Zealanders, because it really is quite an outrage that we are, so proud of our Anzac tradition and consider ourselves quite close to New Zealand, but they are really targeted quite differently from people from anywhere else. So you can see there the evolution of the system becoming harsher. There was a lot of media around 1996 when I believe I worked at Welfare Rights Centre a long time ago, about the Bondi bludger. So the idea New Zealanders are coming here and they're either taking all our jobs or they're lying on the beach on the dole. No mention about the tax they're paying or the work they're doing or anything of that nature. Consequently, New Zealanders tend to arrive in Australia on a special category visa because that means they don't have to apply a visa before arriving. That is largely because if they weren't coming on that visa, they'd have to go down the regular immigration pathway and apply for a skilled visa. Once here, there is no system that prompts people to become permanent residents or consider changing visa status. So people are often unaware of what that means until the disaster hits. For example, COVID, when they realize they're locked out of Centrelink payments when a crisis hits. There's a small group who arrived way back in 2001 who are considered protected, but basically everyone else is not considered an Australian resident for social security purposes. They are for tax, for superannuation, but not for social security. And that means they can get nothing, absolutely nothing in terms of income support except for a single one-off 6-month payment of job seeker if they've lived here for 10 years or more. And that's where I wanted to make sure I mentioned the issue of special benefit children. So if an adult or parent is not eligible for income support because of residency, which is not just New Zealanders, anyone because of residency, but their child is eligible because they're a permanent resident or Australian citizen, then the child can in fact apply for special benefit. There is no lower age limit. So we see babies being paid income support that the parent or parents rely on. That payment will stop once a parent becomes a permanent resident and it flicks back to a more logical system of, providing the income to the adult. But importantly, the child cannot get special benefit while getting family tax benefit. So that then shrinks in again the income that Kerry and her child can get. If she is able to make her way through the system, then she could claim special benefit for her daughter or family tax benefit. Usually special benefit will be the higher option there. And just a note again that this won't affect her visa status because she's just on that special category visa that just rolls on. So yes, at that point, are there any questions?
I don't think we've actually had any questions in the Q&A, and it might actually work well to keep going given the time and then do questions at the end.
Yep, great. Thank you.
Hi, sorry. also having technical difficulties. It's nearly 3:30. Low blood sugar 3:30 moment. Can everyone see the slides again now? Someone nod at me.
Yep, we can.
Okay.
See them, yeah. That's
Great. Thanks, Imogen and Sally. So I'm Emily from Economic Justice Australia and have practiced as a social security lawyer and immigration lawyer. And Anne and Sally have painted the picture for you both around the point in time with a migrant or refugee's journey in Australia where they might have no access to social security support. So that's generally on most temporary visas. Sally's then gone through the point in time where people might start to get some access to social security support subject to the newly arrived residents wait period and other issues. And I'm going to finish off the session talking about the point where people gain access to the social security system. Usually they've become a permanent resident or they're on a temporary visa that tracks eligibility, and talk about how the systems continue to collide for people who are experiencing family and domestic violence. So coming back to our first case study of Ali, thinking about her situation again, but this time Ali has decided to stay with Mark because it's too difficult for her to leave. She's facing homelessness and poverty, remembering through the period of time on a temporary visa, she had no independent income of her own, and she's deciding to stay. As Sally explained, her and Mark have applied for the partner visa, and Ali now holds the temporary partner visa, the subclass 820. At this point, she becomes eligible for some Centrelink income support, as Sally has explained. This might include the special benefit if she has the wait period waived, but could include the family tax benefit B, for example. This is a way that she can finally, hopefully, support herself financially somewhat, even with these limited payments. Ali applies to Centrelink, and she has to tell Centrelink what her relationship status is. The group that spoke before us talked about how people are linked to their partner if they're a member of a couple for the purposes of determining whether they're eligible for Centrelink. She tells Centrelink she's in a relationship with Mark, and they decide that she's a member of a couple. She's married, she's living under the same roof, and she meets most of the factors that Centrelink consider. This means all of Mark's income and assets affect her eligibility for Centrelink at this point. It also affects the amount of income support she can receive. All of Mark's income and assets also affect the rate of payment that the family can receive through the family tax benefit. Ali continues to experience family violence, including economic abuse, as described by Anne and Sally earlier. She's not able to independently access any of Mark's money and has no financial independence, as we understand. You can see that at this point, Ali's relationship status is relevant to both her Centrelink eligibility and her visa eligibility, being on the partner visa pathway. So what happens to Ali when Mark's income pushes her over the income limit for Centrelink? She no longer has an independent source of income. What could she do about this from a social security or Centrelink perspective? One option for Ali, and this was discussed earlier as well, so I won't labour the point, is if she isn't planning to leave the home, she is likely to continue to be considered a member of couple by Centrelink. But she could ask Centrelink to start considering her as not being a member of a couple for a special reason pursuant to the special reason discretion under the Social Security Act. What is this special reason discretion? So the non-lawyers in the room don't need to hear about Section 24 Social Security Act. What is this special reason discretion? What it is a discretion that enables Centrelink decision makers and Administrative Appeals Tribunal decision makers, if it gets to that point, to decide that there's a special reason not to treat a person as a member of a couple for the purposes of determining their Centrelink eligibility and rate of payment. That's the extent of how far the decision goes. There's 3 questions that must be asked as part of this consideration. Is there a special reason? In Ali's case, family violence could be that special reason. Is there a lack of ability to pull resources for the member of the couple as a result of that special reason? Is there financial difficulty as a result of that special reason or of the couple's circumstances more broadly? Thinking about Ali's case, how might these questions be answered? You would think that all of these questions could be answered positively, and that on paper, the special reason discretion could be applied. If it were to be applied, using the family and domestic violence that she's experiencing, Ali could be considered to be a member of a couple, but not be considered a member of a couple for a special reason, purely for the purposes of determining her Centrelink eligibility. How might this, though, affect her visa status? If we come back to the underlying visa that Ali holds, she holds a partner visa, which is at its eligibility level linked to her relationship with Mark as the sponsor. If Centrelink have made a decision that she's not to be considered a member of a couple, we need to consider whether that might have flow-on effects for her visa. I won't go over this at length, but a lot of people sitting in the room will be saying, it shouldn't matter, because if she's experiencing family and domestic violence, she might be able to engage the Migration Act family violence provisions that Sally and Anne have both mentioned. But let's leave that aside and focus more on the collision between the two systems here. It's crucial for Ali herself and those assisting her and decision makers at both Centrelink and the Department of Home Affairs to be aware of the potential impacts of a Section 24 discretion decision or a special reason discretion decision. And why is it important? A Section 24 or a special reason decision is a finding, as I've said, that you are still a member of a couple, but should not be treated as a member of a couple for the purposes of your social security entitlement. You can see how convoluted and confusing that might be for people experiencing this themselves, immigration lawyers who aren't social security lawyers, decision makers at the Department of Home Affairs. And that's where it becomes problematic. In Ali's case, if she successfully had a special reason decision made granting her access to Centrelink and not linking her to Mark's income and assets anymore, she might end up with a decision like this, whether it's made by the tribunal or by Centrelink directly. What's quoted on the screen here is a recent decision of the Administrative Appeals Tribunal in a case with a pseudonym GRYB. GRYB was a woman living in Australia experiencing family violence and accessing Centrelink. She asked Centrelink to find that she shouldn't be considered a member of a couple for a special reason because she wasn't able to access her partner's income and assets. The tribunal found that she shouldn't be considered a member of a couple for the purposes of her Centrelink payments because of the family violence she was experiencing. But how they phrased that finding was, as is quoted on the screen in front of you. They said the tribunal sets aside the reviewable decision and remits the matter to the respondent, which is Centrelink, for reconsideration with the finding that there is a special reason why the applicant should not be treated as a member of a couple. This is a somewhat of an oversimplification of what the Section 24 or the special reason discretion actually empowers decision makers to say. At its core, the discretion requires that you are still considered to be a member of a couple, but you should not be treated as a member of a couple. And that's really critical, because if that was understood correctly and applied correctly in decisions, it might not pose such a problem for people who are relying on the fact that they are a member of a couple for the purposes of their visa eligibility. We've touched on the fact that someone in Ali's case might be able to utilise the family violence provisions under the Migration Act, and so it wouldn't matter if she was still considered to be a member of a couple or not by Centrelink. But let's imagine that Ali holds another type of visa. Some that come to mind are the temporary forms of protection visas, or skilled or student visas, where people are living in Australia potentially as a dependent on their partner or the perpetrator's visa, where they might have no substantial eligibility for the visa that they hold in their own right. They're purely a dependent on the visa. In that situation, or in Ali's situation, We want advocates, support workers, and individuals themselves to think about how a decision made by Centrelink about the couple status of a person might impact the visa that she holds. I'll just make a quick note because I think I'm running to time. But there will be people sitting out there thinking, well, why wouldn't we argue that no relationship exists at all in this scenario? And in some circumstances, it might be more correct to do that. It depends on how your client defines the relationship themselves. Do they see a relationship and they're experiencing family and domestic violence in that relationship? Or is the existence of the violence enough to have led to a complete breakdown of the relationship altogether and they're merely living under the same roof? That's really important to understand, to work out whether we should try and use the Section 24 discretion or the special reason discretion, or make an argument that there's no relationship at all. Where that second argument could be very problematic for someone on a visa, where that visa eligibility is tied to their relationship, it's important to consider whether the special reason circumstance is a better tool to use for the purpose of their Centrelink eligibility than making an argument that no relationship exists at all. So I'll pose some questions and then allow you to ask questions, questions to the group. I think I've maybe answered it, but there'll be lots of different opinions. In a case like Ali's or others similar with different visas, you know, there's thousands of different scenarios. Is the Section 24 special reason discretion the right pathway? Is not a member of a couple at all the right pathway? And what are all of the relevant considerations? We'll go through after having some questions now, or if we're running over time, I'm happy to jump straight to it. We'll go through some of the things that we think we can do as a sector from a decision maker level through advocates and support workers. But do we want to have questions now or keep going through and have all the rest of the questions at the end?
I think we'll just keep going, Emily. We do have a few questions, but I think get through
I'll save them. Yeah, okay. So we've highlighted a lot of different issues where these systems collide and there are either complete barriers or very difficult to overcome barriers for people experiencing family violence who are living on temporary or permanent visas in Australia in terms of their access to income support from Centrelink. So what can we do as advocates, support workers, lawyers, decision makers? I know there's all of us in the room and people going through this process themselves with lived experience. We need to be attuned to our own or our clients and customers' visa and residency status and consider how this is relevant to the advocacy or decision making we're involved in. We should also consider whether our clients or customers should be referred for immigration legal advice, social security legal advice, family law advice. We're not even touching on the way that intersects with these two issues too much today. And of course, family and domestic violence support. This might be a very obvious thing to say, but it's amazing how many people come to you and they've seen one practitioner within this list and that person hadn't referred them on for any further advice for the other issues that they're experiencing. We need that holistic intersectional approach for people living in this kind of scenario and everyone. And where we have other workers in place, we need to make sure that we're working together and communicating effectively. I'll hand over to Sally to talk about what we can do from a reform perspective.
Yeah, so I wanted just to remind people of the history, the evolution of the newly arrived residents waiting period, just as one example to make the point that this stuff is not set in stone. There's nothing absolute about the conditions as they stand. You can see there it came in 97 and gradually just got harsher and harsher over time. Unfortunately, we got the current system in 2019, but then we saw what COVID did in 2020-21 when it was suspended in response to a crisis, clearly, but in, you know, changing conditions. So that next slide, Emily. Or do you want me to share? Yeah. And just that point that it almost got a lot worse. So very recently, it seemed like that, in fact, the newly arrived residents waiting period was going to apply to every payment uniformly, except childcare subsidy, for 4 years in the interest of consistency, I think was the rhetoric. It went through the lower house. It was referred to a Senate committee who said, yes, that looks fair, reasonable and unproblematic. And then there was a change of government who they've come in and they've said they won't be doing that after all. So I guess that is making the point, advocacy, it's worth it. It's important that we get our, what we know, it's important that we communicate it up and we get that up there to the decision makers. So this is just a bit of a look at a few of the things that EJA has done on domestic violence, particularly, and social security in the last few years, starting with those 2 reports which argued for reform. The first report, the blue report, we actually got some of those reforms through under the previous government, and we're now working to get the rest of those through, and also the recommendations from the green report there. Most recently, that's the legislative brief that you can see there in orange that has gone to the government with, I think it's up to more than 60 organisations now have signed on trying to get some of those key reforms through. And we've heard today, we do seem to be getting somewhere with many of them. So some of the key recommendations from those pieces of work are that we see increased training for Centrelink staff and more social workers so that they are able to flag when it seems there may be domestic violence for one of their clients and streamline their access to payments. We've asked that they amend the Act to at least make it possible for special category visa holders to access special benefit, particularly if it's unreasonable for them to leave Australia. For example, our scenario had a stop on a child's passport. That's common, or people get caught in family law proceedings. They can't leave. Usually it's the mother. She can't leave with taking the child with her, and she has nothing to live on while she's staying here waiting for those things to unfold. We've also asked that just that particularly harsh treatment of New Zealanders be resolved so they are at least treated in the same way that other newly arrived migrants are treated. And the fourth one is, making those arguments around Section 24 being more clearly recognised as applicable in cases of family and domestic violence so that a person can get a single rate of payment or just get a payment at all. And I think that the big one here, clearly from Anne's presentation, is extending social security to victim survivors who don't yet have permanent residency and are here and have experienced domestic violence here and are able to access nothing to extricate themselves from, their situation. And just to reiterate, we're well aware of the tension with the migration process and working to ensure that we don't remove any options for people and jeopardise their immigration status. And do you want to revisit the blueprint?
Yeah, I'll just briefly touch on it because I brought it up earlier. But there's a national advocacy group for women on temporary visas who are experiencing family and domestic violence. And in 2018, I believe, they prepared this blueprint for reform. It covered, broad areas seeking reform. For seeking reform, which are improvements to the migration system. As we touched on with the question from Leanne, looking at clearer pathways to security and ideally permanent residency for people on temporary visas experiencing violence. The second key area was better eligibility and access to social support, which overlaps with the work of the EJA. And finally, long-term funding for specialist services working in this space. I'll probably just leave it there so we have time for questions.
And the last thing that I wanted to mention is just the big picture, that we've said it earlier today, that this needs to get into women's policy and family and domestic violence policy. There is a lot of money obviously not enough to fix the problem, but compared to social security or migration, there is a lot of money going into this area, and there's a lot of goodwill, genuine goodwill to attempt to have a better system to respond to family and domestic violence. We need to ensure that social security is part of that, because we need the minds of the people who are doing that work to be attuned to what we are talking about. It is the way to get the experience of every refuge worker in Australia who know all this stuff that we're talking about up into the decision makers' minds. So yeah, the plea is that we push hard to get this into the national plan, but also just more generally into women's policy, and we make better efforts to involve ourselves in those those structures, those mechanisms. Because I think that, sorry, I just wanted to end with that question, that so often it's about one super vulnerable person who's here and how terrible it is. But I think we need to start from another point, that this violence is happening in Australia, quite often by Australian permanent resident and citizen men. But is it right that some women are able to get nothing or less than other women? And that's really where I think the response needs to start.
Thank you, Sally and Emily. I can't see her on my screen now, but it's such a complex issue, and thank you for breaking it down and explaining it to us. And as Emily was saying, we all need to work together with our different expertise in order to provide that holistic service that's really going to address these clients' needs. The first question I have, I think, Sally, you've started typing an answer, so I might direct this to you. If family tax benefit is taken by a partner and the child is living with the permanent resident parent, then what would be available for our client?
So I think that's referring to the New Zealand scenario, do we think? That
or just a percentage of care where it's given to one and not where it's given to the perpetrator? Is that
no? It was more if the perpetrator has the child and the woman leaves. If it's a New Zealand permanent resident, it is my understanding that in our case scenario where she had been here for less than 10 years, she gets nothing. Absolutely nothing, including if there is a stop on the passport or if there is a family court proceedings that she is waiting for. But feel free, lawyers, to tell me if I got it wrong.
Emily, is there any more of that?
Not to that specifically, but just to talk about a case that I've experienced where the New Zealand citizen woman was still living with the child who was eligible for special benefit, and she was receiving it, but because it was special benefit on its own for two people, which is completely inadequate, she started allowing the perpetrator to access the property again with the key so that he would pay their rent, and Centrelink then deemed that income, and she lost the special benefit and was forced to rely on the perpetrator because of the system. That's ultimately what happens for people in such a desperate situation where they either have absolutely no eligibility or they're only eligible for something as low as special benefit, which is just a completely inadequate payment. And when you're not receiving the family tax benefit on top of it, it is not enough to live on. It is not enough to pay rent in any Australian city. It just isn't sufficient. So just to reiterate that point with a particularly pertinent case study.
I do think there's such a misconception that special benefit is just there as the last resort payment. And I remember the former Prime Minister getting up at the beginning of the lockdown saying to the press conference, it's okay, temporary visa holders, students, whoever, that's not covered by job seeker or job keeper, they're just going to get special benefit, which is completely erroneous, as we all know. So I just wanted to make that point. And really, Ali's case that you've taken us through today just shows what an appalling situation that is. Ali needs support. She's at risk. And really, it's a travesty that accessing special benefit is just so problematic. So one last question, we've got 1 minute till the next session. In terms of New Zealand residents in Australia, whether international agreement with New Zealand should be changed to include pensions other than the disability support pension.
I mean, personally, I think it should be. We have, as Sally touched on, a very close relationship with New Zealand. We value our mateship relationship. We work together so closely on so many other areas. Recently, we've seen the Prime Ministers working together to push to give voting rights to New Zealand citizens who live in Australia. New Zealand citizens might live in Australia their entire life. They might move here as a child and only ever study, work and pay taxes in Australia. They don't have a clear pathway to become Australian citizens. They live on a visa that prevents them from accessing all of the supports that any other resident, living in that permanent way in Australia has access to. Absolutely, there should be an agreement that they're eligible for not just special benefit, that's the low-hanging fruit, if that's even possible, but for all of the other payments that are available, in particular payments like the disability support pension, the age pension, parenting payment, but really I would say every payment. I can't see why it shouldn't be the case.
Yeah, it seems incredible that people make a logical decision at one point in time, when people plan things, it's simple, it's straightforward to come to Australia. You don't need to go through a complex process to get a visa. And then they're locked into a system that during COVID, I don't know, in Facebook groups, I was seeing people going, I'm from New Zealand, how do I be, like people trying to untangle it and having no idea. So as Emily said, it's incredible that people can live here for their whole lives and not access things, including things that people who've come from any other country in the world and been granted permanent residency can access after 4 years or maybe 10 years age pension. But still, it's extraordinary how it lands.
Thank you, Sally, Emily, and for a really fantastic discussion.